Welcome to another episode of Family with Judy. I am Ken the Drone Guy, and with me I have Carol, and I have Judy, the family lawyer. Now, last time we spoke about conflict and divorce, and today we're going to speak of what happens right after divorce, and specifically to the property. Judy, what happens to family property after divorce?
Okay, an interesting question. First of all, I need to say that sometimes there is no property, and so parties dissolve the marriage and go their own ways. But in a case where there is property, many people are able to agree on how to share the property, and on their own or with the assistance of a mediator, they're able to come up with a formula, of how to share the same. Okay, and it's based on, I guess, what they both want. Okay, but in the event that there is no agreement on how to share property, our recourse is within the Matrimonial Property Act. I need to tell you that this act, Matrimonial Property Act, was long awaited, and it became law in 2013, December of 2013.
Okay.
And just to give you a bit of background, if I may, we did not have our own local act. So as a country, we borrowed law from an old act of England. It was called the 1882 Married Women's Property Act of England, 1882. Okay. And that's the one we had in place until 2013, December.
Oh, wow.
What a shame.
Oh, wow.
We hadn't found space in our liberated, independent time to have a law for ourselves. So a lot of lobbying was involved to bring forth the Matrimonial Property Act.
Okay.
And the reason why there was so much lobbying is because the English Act of 1882, by the way, the English themselves had moved away from that act, like in 1967 and many other acts. So it's only us who are left applying it, you see. It provided very little of substantive law. It only provided that a high court may determine a property dispute between a husband and a wife. So our judges over the time came up with what we call judge-made law, because where there's a gap in statute or in an act of parliament, then the court can formulate what we call judge-made law. The only thing is that it's not sustainable, because once an act of parliament comes into being, as this one became, then that becomes the law of the land. So over time, and I must credit our judges, they'd come up with, first of all, a decision to the effect that that act, the 1882 Act of England, was applicable in Kenya, in a case known as I versus I, a long time ago. Then after that, in the case known as Karanja versus Karanja, they came up with a decision that that law is also applicable to customary marriages. Okay, and over time, they then said that for property to be divided, consideration must be had to the contribution of the parties, even though the property is registered in one spouse's name.
Oh, wow.
Okay.
So I'm curious, what kind of contribution did one have to prove, and what was awarded by the courts?
I see. A very interesting question. So the kind of contribution that one had to show was either financial, and even financial could be direct or indirect. By direct, I mean that you're paid into the asset, right? Indirect means that you took care of family expenses financially. So even though it was financial, it was indirect. So that contribution counted. And then there was the non-financial contribution. So that included childcare. And one of the judges gave an example in a famous case known as Kivuito versus Kivuito of what contribution would look like. He says, take the case of a housewife in an urban household. So who cooks meals and washes clothes and takes care of the household. If the husband goes to work and from that work or business earns money, which he invests in a property, the court said that one woman would be entitled to a share of that property. What the court did not say is the percentage that the woman would get. But in that particular case, it ended up giving a 50-50. What I'm trying to say is that the proportion depends on the contribution in every particular case, and is therefore left to the discretion of the judge who is hearing the case. Then the court said, take also the example of the woman apprentice who tills the land, keeps animals, takes care of children, or the husband comes to Nairobi or to an urban center and works or does business and acquires property. And the court said, even that woman would be entitled to a share of that property. And of course, there is also the woman who's going to work, or the man who is going to work, earns an income, while the other spouse is also earning an income. Their contribution, both financial and non-financial, will count to the eventual distribution of their property. So in terms of percentage, like I have said, in some courts, they give 30%. In others, they give 40%. In others, they give 50%. In others, too, they give 20%. In the end, it depended on the judge who had the matter and, I suppose, the circumstances of the matter. And that was the case for a long time. By 2003, the courts had got to a point where they said that in a case where a man and a woman are married, and where property is acquired during the marriage, there is a rebuttable presumption. There's a rebuttable presumption that the couple is entitled equally to that property. Rebuttable means it can be rebutted. That was 2003. And so we could almost advise people who came along that they are going to be able to get a share of the property, even though registered in the other spouse's name, so long as they were able to show either financial or non-financial contribution. But unknown to us, there was some shock waiting to happen along the way, because in 2007, a 5-court bench of the Court of Appeal, and by the way, that was the highest court in the land then, because we didn't get a Supreme Court until the 2010 Constitution. So the highest bench we could get, the highest court we could get was the Court of Appeal, especially sitting as a 5-judge bench. Reversed all those gains, because the court said, we do not have a law that provides that non-financial contribution should count in a matrimonial environment. The only law we have is the law of the land, where you and I, or any other two people out there, put their money into a property, and those people can only get a share of that property to the extent of their financial contribution. So they said, so long as we do not have a local act of parliament regulating or providing how property in a domestic setting can be divided, then we have to continue using the law of the land that we would use on any other people outside there. Can you believe it? So they then said, in a nutshell, that a husband or a wife, or a former husband or wife, needed to show financial contribution, and it's only to that extent that they would be entitled to a share of matrimonial property. And it was shocking. That decision was shocking. So what did we begin to do? Major efforts were put into coming up with a matrimonial property act of ours that recognized the circumstances of Kenyan families. So between 2007 and 2013, we were using that law that said that you had to show financial contribution. In 2014, therefore, when President Uhuru signed the Matrimonial Property Act into law, and after Christmas, I never forget that, after Christmas, and it was to come into effect in January of the following year, we were all very excited, because finally we knew what matrimonial property was, finally we knew what contribution amounted to, and finally we had resort to a local act of parliament. So that's why the history is very important to get into. By the way, the case in which it was determined that you had to show financial contribution was it's known as Isharia versus Isharia. Mr. Isharia was a diplomat, and so it meant that he was posted in places outside of the country. Mrs. Isharia, a well-educated woman, but followed her husband, and of course, the wife of a diplomat has duties that they perform even official. But even that, the court did not recognize. The court still felt that if she did not make financial contribution, then she did not get a financial share. So the most she could get, the most financial contribution they could see was 25%. So she got 25% and he got 75%. And don't forget, the previous courts had given her 50-50. But this was now a reversal of those decisions. So that's how painful it was. Then came 2014. Came 2013, the law is passed. In 2014, we start to implement it, and it's what we are implementing to date. And I'll be able to demonstrate to you, I hope, before we finish this, that sometimes the saying that the more things change, the more things remain the same could also be used here.